So we had done the module 1 yesterday of the new syllabus. Now this is module 2. We had completed chapter 1 yesterday. So we'll do start with chapter 2 in module 2. Then we'll move to module 3, which is the information to the police and their powers to investigate an inquiry proceeding. Okay. So this is going to be module 3. Don't worry, you'll see everything on the screen once you receive the recording. So let's go to the chapter 2, which is initiation of inquiry proceeding, sections 210 to 214 of the Bharatiya Nagrik Suraksha Sanhita, VNSS 2013. So this section is purely about how the inquiry proceeding happens, and which is described under section 210 to 214. And one very good thing is the new syllabus is not that vast. So it is very easier for you to score if you are preparing with this program which I'm running right now. And then end of the program, I'll give you a link where you can get that particular book to get everything what I'm teaching you right now for the new syllabus. So it was planned for some other batch, but it happened now, so you can use it. So section 210 talks about cognizance of offense by a magistrate. Section 210 is basically talking about the cognizance. 211 will then talk about the transfer of application of an accused in case if it is required to be done and why and how. Then 212 will talk about making over cases to the magistrate. 213 talks about the cognizance of offences by the court of session. And 214, then we'll read about additional session judges to try cases made over to them, how they try that. So cognizance of offences by the magistrate. By the plain reading of the section, it says, subject to the provisions of this chapter, any magistrate of the first class, so JMFC, and any magistrate of the second class, which is JMC, specially empowered in this behalf under subsection 2 may take cognizance of any offense. So upon receiving, point A under subsection 1 says, upon receiving a complaint of facts, including any complaint filed by a person authorized under any special law which constitutes such offense, upon information received from any person other than a police officer, or upon his own knowledge that such offense has been committed, the Chief Judicial Magistrate may empower any magistrate of the second class to take cognizance under subsection 1 of such offences as are within his competence to inquire into or try. So we knew that cognizance, the JMC has only a limited capacity to try any matter. The smaller matters, lesser than 1 or up to 1 year, they can try. But the CJM can empower the Chief Judicial Magistrate can empower any judicial magistrate of second class also to take a cognizance and to inquire or to try or both. That power can be extended by the Chief Judicial Magistrate depending upon that. You might remember a similar thing we have read in the previous section in CRPC where the High Court can also empower any civil judge also to act like a magistrate in the criminal court. So what does it mean exactly when we talk about section 210? So there is an authority to take the cognizance. So section 210 basically talks about a mechanism by which a magistrate can take cognizance of offences, thereby initiating the legal process for prosecution. So this provision is very essential to ensure that appropriate legal action can be taken based on various forms of information regarding criminal activities. Now, I'd like to highlight one thing here is there are multiple Supreme Court matters, judgments which have come up in this direction, which you should read, which talks about there is again a limitation. Although the magistrates can take a cognizance, but only up to the level of certain extent they can operate. They can only ask first the police department to go ahead and investigate in that area. Immediately an FIR filing is not allowed. So basically, JMFC can do that. JMC can never do that until and unless the JMC is empowered by the CJM for specific matters to where he can indulge or she can indulge themselves. So there was a famous matter recently in Supreme Court, which had gone up to the Supreme Court in appeals, where a JMC had done the similar thing, and they had gone ahead, and not Supreme Court, I'm sorry, this has gone to the High Court of Bombay, where the matter was brought to the notice to the court that a JMC had instructed the police to do a investigation, which was completely overturned and quashed by the High Court, saying in those cases where JMCs are not specifically allowed by the CJM as on instruction by the High Court, it is really impossible for the JMC and not appropriate for the JMC to give instructions to the police for any investigation or indulge into such matters by themselves. So that they cannot do it. So then again, this section types about types of cognizance. So the types of cognizance could be a complaint. So a magistrate may take a cognizance upon receiving a formal complaint detailing factual allegations constituting an offense. So this includes complaint from authorized individuals under special laws, which facilitates a wider range of inputs that can trigger legal proceedings. For example, a complaint filed by a victim of domestic violence would enable the magistrate to initiate action based on the presented facts. So they can go ahead and do it. Sometimes I think I remember I mentioned a previous example also of one of our own clients as well, where the client had a was there was a case of cheating with the business partner where there was no delivery of the goods which was made as per the schedule and the payment made in advance. And when the police was not able to understand they should file a cheating case or it's a civil matter, the matter went to the judicial magistrate and then an inquiry was ordered. So that is, these kind of examples are where a complaint comes from people and the magistrate can take a cognizance and order based on the presented facts. Second types of cognizance which they can take is also a police report. So cognizance can also taken based on police report that presents factual findings regarding an offense. Importantly, this can be submitted in various formats. For example, it can go in electronic versions also, which is now allowed in BNSS. It can reflect any way which is conventional also. For example, a police report, which is document a finding of a robbery investigation, would allow magistrate to proceed with the case. Or a report, secret report from the police, which has gone to the magistrate for the local area for certain search operations and arrests to be made. So information from other sources also is valid. So magistrate can also act upon information received from sources other than the police officer based on their own observation also, indicating that offenses has been committed and they can operate. So this grants magistrates significant latitude in addressing offenses that might not be formally reported through the conventional channels. For example, a magistrate learns from community reports about possible drug trafficking in the area. They can take in cognizance, initiate inquiry action with help of the police. So the empowerment which is given by section 210 is vast, where magistrates not only through the formal channels where the cases are filed and then it has reached through their court, it was as per the rotation, it has come to their court and they are enlisted on the board. No, apart from that, they can also take complaints, police reports, information from sources and their own cognizance as well. So this is one part. Third part, what this section talks about, the special empowerment of the second class magistrate also, which is in subsection 2, clearly written. So the section allows the chief judicial magistrate to empower second class magistrate. Now understand, this can only happen by the instructions of the and the guidelines of the High Court to take a cognizance of offences within their jurisdiction, in only their jurisdiction. This ensures that the lower tier magistrate can also handle cases appropriate to their levels of authority, thereby alleviation, the workload sharing happens on the first class manager of a magistrate and the improving the efficiency of the judicial system. So a CGM may designate a second class magistrate to hear minor theft cases that magistrate can directly take a cognizance of theft offences. So it is authorized to the JMC also. So this the practical implication why this section is there is also to increase accessibility of the magistrate to the kinds of areas where he or she can bring a relief. It also streamlines the legal provision or helps in load distribution for minor kinds of matters which are straightforward, having a lesser number of punishable number of years. and that could be also aligned and assigned to the JMCs. So in summary, this is what is section 210. Section 211 then talks about transfer on application of accused. So an application is made for transfer. So when a magistrate takes a cognizance of an offence under clause C of subsection 1 of subsection uh, 210, the accused shall, before any evidence taken, be informed that he is entitled to have the case inquired into or tried by another magistrate, and if the accused or any of the accused, if there be more than one, object to further proceedings before the magistrate taking cognizance, the case shall be transferred to such other magistrate as may be specified by the CJM in his behalf. So what does it say? It talks about the right of the accused. So it enables in establish a very important procedural right for the accused. We said BNSS is also looking towards accused. So particularly concerning their entitlement to seek a transfer of their case to a different magistrate. This provision underscores the principles of fair trial and judicial impartiality by empowering the accused to express their preference regarding the judicial authority overseeing their case. Of course, this cannot just happen by the whims and fancies of the accused, but this is something which is depending upon the necessity of various other reasons, and which is looks suitable for the magistrate also, that it will be possible for better run that particular matter with a different magistrate for different reasons. Then only it's a discretion of the court, but then this possibility, this is also given as per this current section, which is 211. So the notification of the right is also one part of this section, which talks about when a magistrate takes cognizance of an offense based upon information received from sources other than police, as per clause C of the section 210. So clause C is referred in 210, where clause C clearly says, upon information received from any person other than a police officer or upon his own knowledge that such offense has been committed, and magistrate can take a cognizance. So this section we are talking about, it is mandatory for the magistrate to inform the accused of their right to request that the case to be tried or inquired by another magistrate. So this notification must occur before any evidence is presented. So when the evidence stage is reached, before that it has to be done, or taken during proceeding, ensuring that the accused has the opportunity to exercise their right without the influence of prior hearings. Now, objection to the transfer. So if the accused or any other co-accused raises, say for example, an objection to any proceeding with the case before the current magistrate, the provision allows to transfer of the case to another magistrate. The transfer must to be a magistrate specified by the CJM, who oversees the administrative aspects of the judicial system and designates appropriate venues for trial. So if multiple defendants in a case feel that they cannot receive a fair trial due to potential biases perceived in the current magistrate, they can object, prompting a transfer to ensure fairness, and they have to write to the CJM for that. The application should be directed to the CJM. You cannot write the application to the same magistrate to transfer your case to some other magistrate. For example, in High Court also, in Supreme Court also, in High Court also, you have a option where you can go ahead and you can get a change of the judge if you have strong reasons to believe or express that there are biases. Then you have to go to the Chief Justice of the High Court, make an application through the registrar. The investigation will happen, and through the registrar, both the parties, the judge and yourself, will be notified if the case is moving to other court, or the Chief Justice believes it has to stay in the same court with the reasons. So the procedure is there. What is the key purpose such kind of section would have come is, of course, to enhance judicial fairness, because end of the day, judges are also people. There might be reasons where somebody might be biased, and or at least you might feel that is biased. So you have all rights to, at the very initial stage, go ahead and get a transfer. And this is also to enhance the integrity. So the requirement for a transfer on objection fosters procedural integrity by ensuring cases are handled by judges who are dealing it very deem appropriate way and with fairness. So that is about section 211. Moving ahead, section 212. So when we see section 212, section 212 says any chief judicial magistrate may, after taking a cognizance of an offence, makes over the case for inquiry or trial to any competent magistrate subordinate to them. Any magistrate of the first class empowered in this behalf by the CJM may, after taking cognizance of an offence, make over the case for inquiry or trial to such other competent magistrate as the CJM may be by general or special order specify, and thereupon such magistrate may hold the inquiry or trial. Now, what is a general or a special order? So, general order is basically the general office orders which are more in operational in nature, where a decision is made of the framework on who will take care of which jurisdiction matter, what kind of matters, which specific section related areas, in a city, which specific sub areas. So, those are the general instructions which are given. Special order may come in case some exception or some uh, urgent matter has come and that has to be instructed. So CGM once receives a cognizance, they go ahead and make a case for make over the case for inquiry to for trial or inquiry to one competent magistrate. And any JMFC is empowered in his behalf by the chief CJM that after taking cognizance, they can again pass it on to any other magistrate. So it's not like that the CJM will send it to JMFC and then JMFC will go ahead and pass it on to a junior magistrate. It is as part of the general procedure which is already there. So what does this section contains inside it? So this first of all talks about the authority of the chief judicial magistrate on assigning, making over any case to any magistrate. Any competent subordinate magistrate to in his jurisdiction, he or she can probably bring in this case and make it over to that magistrate to try. The CGM will acknowledge the offense. Once it is received, they will acknowledge the offense and then they can assign it to task to delegate to some other magistrate subordinate to them. For example, a CJM, if takes a cognizance of a fraud case, the one which I was mentioning, but it is overwhelmed with the other cases, then they can assign this fraud case to any other first class magistrate in the same district to ensure a timely prosecution and trial happens. So this was first part of this section, which talks about the power of the chief judicial magistrate in making over cases to other magistrates under its subordination. Then part 2 of the same section talks about empowering the judicial magistrate of first class, JMFC, as we call them also in short, first class magistrates. So in addition to the CJM's authority, this also gives an authority to the JMFC, which is again empowered to them by CJM only, which is again in turn is an instruction which is formulated and governed by the high courts. So this empowers a lower tier magistrate to take an action that enhances operation efficiency, which is JMC. While ensuring, so there are rules and various general instructions which are given on number of cases per court and the baselining on number of weightage on the court and all those things. When the lines are crossed, the JMFCs are then second level of the in the hierarchy under CJM, who can take an instruction as per given by CJM to pass it on and empower it to some JMC as per the given instructions again. So this is all completely technical and it's like mechanical switches, but this is always the switches are pressed when the requirement comes, and this requirement of the situation when comes, the pressing of this button is something which is empowered by section 212 or any such sections going ahead. So this is in the organization structure, they'll push it to the lower level so that the general directive or specific order they can in the jurisdiction, they can allow within their jurisdiction the JMC to power. So, for example, a first class magistrate, JMFC, receives a case concerning a theft. Now, they can transfer it to another designated first class magistrate, or following the authorization provided by CGM, or even if there is an instruction in that sense, move it to a lower level JMFC as well. So, this brings an efficiency and maintaining the judicial flow. So, a judicial flow is maintained in this way. Now, let's move to section 213, which says, except as otherwise expressly provided by this Sanghita, which is BNSS, or by other law for the time being in force, no court of session shall take cognizance of any offence as a court of original jurisdiction unless the case has been committed to it by a magistrate under this Sanghita, which means jurisdiction of the court of session is defined first of all, where the authority and the jurisdiction of the court of session regarding the cognizance of offences, the provision outlines there is a fundamental principle in the criminal justice system that the court session cannot initiate proceeding on its own unless certain conditions are met. So if you see the BNS or BNSS, there are schedules where it is clearly written which kind of offenses could be tried by which kind of courts, and until and unless those conditions are not met, session court cannot take that matter. So there is no original jurisdiction without a magistrate's commitment. So the court of session is defined as a court of superior jurisdiction. So that is meant to handle more serious criminal cases such as bigger crimes of sexual offenses, felonies, etc., theft, robberies. Moreover, it cannot exercise its authority to take cognizance of offences unless those cases have been formally committed to by a magistrate. For a serious crime such as a murder is alleged, the local magistrate must first conduct preliminary inquiry and then commit the case to the session court for trial. The session court does not have the authority to take cognizance without the commitment. It can, if it is not committed to it, it will not take it. So what are the conditions for taking the cognizance? The explicit condition outlined in section 213 is the importance of the procedural hierarchy within the criminal justice system regarding the session court's applicability towards taking the matters, and such provisions help ensure that only cases that have undergone preliminary scrutiny and established sufficient basis for trial reach the higher court. In this case, the session court. And what is the logic rationale behind that? The requirement is to maintain a check on the flow of session cases to the higher court, thus preventing unnecessary caseloads and ensuring resources are allocated properly. If an efficient, bigger machinery has to run that way, it has to run efficiently to cater only those things which it is made to. Otherwise, what is the purpose of having a lower and a higher court of jurisdiction? So some specific laws empower the session court to take the cognizance, particularly offences, without needing preliminary commitment, such as cases of terrorism, cases of special cases of rape, POXO, MOCA. So these cases will come directly to these magistrates or to some uh, through special legislations. So that legislation is already defined, and those are the switches which are by default on, where these matters will go directly to the session court. What is the practical implication of doing it? Again, a streamlining of judicial process. What has to go up to what level, which level of machinery of the judiciary at what level has to be utilized is very, very important. And that is why this is put there, and this upholds the proper legal structure. The last section for chapter number 2 is section 214, which is additional session judges to try cases made over to them. Now, we were previous section talking about what cases cannot be made to them and what cases are by default coming to them, and what are the restrictions there and what are the reasons. While 214 talks about an additional session judge to try cases made over to them. So what is an additional session judge? Additional session judge is nothing but a judge which is a copy and paste in terms of power and duties of a session judge only, but just to distribute the workload. Okay. So that is why we call them additional session judges. We spoke about it in one of the previous sessions. So the sections 214 says an additional session judge shall try such cases as the session judge of the division may, by general or special order, make over to him for trial, or as the High Court may by special order direct him to try. Now, it is not that when every time a matter goes, that matter goes to the session judge, or in this case goes to the Chief Judicial Magistrate. Please understand, the practical application doesn't work this way. The practical application, how it works is everything is decided as per the legislature, which is then interpreted by the higher court, the High Court. The High Court then weaves those guidelines and keeps changing it time to time, and then that is gone to the session level. The session level, the session judges, the CJM for the other magistrates, session judge for the session, additional session judges, they have those guidelines which is already there. If there is a liberty given to them where they have some sub tuning they can do, for example, depending upon so and so area, for example, in cyber crime, some cases might go to some judges who are handling online filed matters. Some cases might only handle cases which are which have FIRs and which are not only online based. So those kind of flexibility is given to the session judge level or the CJM level. So those rules they draw. Once those rules are drawn, that is then moved to the registrar. Registrar then gives it to the clerks of the court at the back end who manage those registration of the cases and making over it to the judges. And that rules are then read day-to-day basis by the clerks, not by the judges. It can be challenged by the judge if it reaches to their desk and it shouldn't have been, or if there is a matter which is not listed in the framework, it comes as a special matter. So the session judge can try the cases. In this case, this is role of additional session judge, which is mentioned in section 214, and it outlines the responsibility and authority of the additional session judge that in the context of the case trial within the judicial framework, they can try, and the judges are integral to the managing the workload of higher court and ensuring that cases are heard efficiently, and it should only reach to them what is meant to them. From a session judge, the assignment happens, which means by the rule which is uh, sent by the session judge, it is assigned to the additional session judges, either by a general order, which is a directive. As I said, it's an operational stuff, or any special order for any specific case where an application, for example, has been made by police or by a person who has made a complaint, or from a high court instruction for some specific cases. Maybe some specific cases, high court might take a cognizance of it and they can come back to the session judge and say, no, you give this matter only to so and such additional session judge because of some specialization or faith of the high court in that judge. So importance is again we talks about the importance of additional session judges. So when we talk about all these things, we are talking about how the additional session judges are protected by those laws, that only which things which are limited and has to reach to them to ensure they do not have a unlimited workload and they are not sending ahead the caseload to the high court, which is unnecessary and should not reach. Because what is the next level of if somebody goes for an appeal against that decision made is the high court. So if it has to go to high court, the relevant case has to come. It shouldn't happen that a case which is relevant to a JMC or a JMFC should reach the session court and unnecessarily then it goes to an appeal to the high court where it could have actually gone only up to the session court. For example, in a matter of a domestic violence case, if there is a judgment which has come which is considered an impugned judgment, and the party which are affected by it should go back and file an appeal in the session court. What happens if the same matter goes directly to session court? It was not eligible. It was a small matter. Judges have spent their time and energies in spite of their seniority in things which are not supposed to be made for them. And then it goes to the higher court, which is again a wastage of time for the higher court also, which could have been finished at the sessions level only. So this brings in an efficiency in the judicial proceeding and it maintains the judicial standards of work. So that is about chapter 2. Now let's move to chapter 3, which is exceptions to the general principle of moving criminal courts, which is in next sections 215 to 222. So section 215 says, prosecution for contempt of lawful authority of public servants, for offences against public justice, and for offences relating to documents given in evidence. So this section is about the prosecution for contempt of lawful authority of public servant and for offences against public justice and for offences relating to documents given in evidence. So three things which it is talking about. In the three areas it operates. Either a lawful authority of any public servant is not abided by, or anything which is related to public justice is not completed, or any offences which is related to an evidence which is given, a document which is given in evidence. So this is a vast section, but let's go. So no court shall take a cognizance. No court will take a cognizance. Number A, of any offence punishable under 206 to 2023, both inclusive but excluding section 209 of the BNS. So anything which is beyond those sections will not come. Just 1 minute. So those sections will not be, it's not possible. So for the to take a cognizance of. So basically what we are talking about, the sections of any contempts of the lawful authority of the public servant, and then we are talking about until end of that particular chapter in BNS, but excluding non-appearance in a response to a proclaimed under section 84 of BNSS. So basically these chapters are nothing but which is connected to the not following the authority of the lawful public servant or office of the public servant. So this is number 1 of section 1A. So no court shall take an cognizance of A, number 1, offences punishable under 206 to 223 of BNS. Then any abatement or attempt to commit such offence. So that also cannot be taken a cognizance of any criminal conspiracy to commit such offence, except on the complaint in writing of the public servant concerned or of some public servant to whom he is administratively subordinate, or some other public servant who is authorized by the concerned public servant so to do. So basically part 1A is completely covering, clearly indicating that anything which is a crime of contempt of the lawful authority of a public servant, that cannot be entertained and taken a cognizance by the court and related to any abatement, etc., or any criminal conspiracy to commit such an offense, but until and unless this is reported by a public servant or any subordinate to them who is authorized to do that by the public servant, because this automatically then comes into what? It also comes into the preview of those matters which are under chapter 13 of BNS, which is of contempts of the lawful authority of public servants. Now, 1B says, no court shall take a cognizance of any offense punishable under the sections of BNS, which are 229 to 233, which are of false evidence and offense against public justice, chapter 14. So anything which is covered between in those sections. So section 229 to 233, inclusive of both, plus 236, 237, 242, 248, both inclusive. So what is 242, 248, which is again purpose of evidence, the crimes which are done. So no court can take a cognizance of this. Then, and we are talking about the criminal cases, how exceptions are there for principle of moving criminal courts. Now, any offense described in subsection 1 of section 336. So any offense which is described in subsection 1 of section 336. So section 336 is what? 336 is forgery. So when we talk about forgery and the subsection of one of this particular section, or punishable under subsection 2 of the section 340 or 300 of 42 of the said Sanhita. 40 is what? Forged documentation, and 42 is what? Counterfeiting documents, devices, document, etc. So all those things cannot be taken into cognizance, and of any criminal conspiracy again to commit such an offense until and unless complaint in writing of that court by such officer of the court as that court may authorize in writing in his behalf, or some other court to which that court is subordinate. So an automatic cognizance cannot be happening for such kind of crimes which are uh, related to against the public justice or related to evidence, document forgery, etc., until and unless this is reported by any court officer or authorized court officer. So previous one was related to public servant's authority. Any contempt happens, then the who was authorized to report was the public servant or the subordinate to him who is authorized. While this is something which is related to evidence and public justice, so the authority is given to the court officers. Now, part 2 of the section 215 says, where a complaint has been made by a public servant or by some other public servant who has been authorized to do so by him under section A clause A of subsection 1. We said, yeah, first part is about public servant, and the person who is only authorized to report is the public servant in writing. It has to be in writing. So any authority to which he is administratively subordinate or which has authorized such public servant may order the withdrawal of the complaint and send a copy of such order to the court, and upon its receipt by the court, no further proceedings shall be taken. So when the public servant is allowed to do a complaint, make a complaint, they are also allowed to withdraw that complaint and send a copy of such order to the court, and upon its receipt by the court, no further proceedings shall be taken on the complaint, provided that no such withdrawal shall be ordered if the trial in the court of the first instance has been concluded. So if there is a complaint which was made for the relation in relation of the lawful authority of a public servant, and that complaint, when it happened, it was instituted in the court. Now, when the court has started to the proceeding of that particular matter, in case for some reason which is justifiable in all lawful ways, then application has been coming to the court again saying we want to withdraw the application. That complaint application can be withdrawn, but if by the time there is already in the court of the first instance where it has reached, maybe it might have reached to first instance, second instance, but if it has reached to first instance of the court and it has concluded the trial, then the complaint cannot be withdrawn. It can justice whatever has been called out, the judgment cannot be cannot vanish in the air, and it will prevail, and the complaint cannot be withdrawn. Now, in clause B, moving to subsection 3 of 215, what was clause B? Clause B was talking about anything related to public justice or related to Evidence Act, any evidence document. So, offense and which was allowed to be in writing to given the authority to the court officials. So, in the clause B of subsection 1, the term court means a civil, revenue, or criminal court and includes a tribunal constituted by under a central state statute, and if declared by that act to be court or the purpose of the section. So we said the court officials are allowed. Which court officials are allowed? The court means a civil, revenue, or criminal court, all the three. And for the purpose of clause B, subsection 4 says, which was again the crime against public justice and order and offense related to documents given in evidence. For this clause B of subsection 1, a court shall be deemed to be subordinate to the court to which appeals ordinarily lie from the acceptable decrees or sentences of such former court, or in the case of a civil court from whose decree no appeal ordinarily lies, to the principal court having ordinary origin civil jurisdiction with whose local jurisdiction such civil court is situated, provided where appeals lie to more than one court, the appellate court of the inferior jurisdiction shall be the court to which such court shall be deemed to be subordinate, and where appeals lie to a civil and also to a revenue court together, such court shall be deemed to be subordinate to the civil or revenue court according to the nature of the case or proceeding in connection with which the offence is alleged to have been committed. So what is the explanation of these sections? Number one, there is a prohibition on taking cognizance, which this section talks about. So what we're talking about, a prohibition of taking cognizance. Now, this subsection 1 in the section outlines restrictions on court proceedings related to offense against public authority. So first part talks about public authority and offenses which are punishable under section 206 to 223, which is against the public authority. So the court may not take cognizance of these offenses unless there is a written complaint from a relevant public servant. So the complaint also that the public servant, whatever related to them, whatever the crime has happened, that is the which is listed under relevant section in the Bharatiya Nyaya Sanhita of the contents of the lawful authority of the public servant, that can only be considered, of course, when it is made a complaint by a public servant. Because if it is a contempt which is made against the lawful uh, lawful orders or the act of that particular public servant, so the whatever the deficiency has happened should be definitely first be reported by the public servant themselves. If they do not report that, then there should not be a third party who can come back and who should make a complaint, which is logically not right also. Part B then talks about the offenses related to court proceedings. If we talk about the evidence documents which are connected and which is something we are concerned about, in subsection B of subsection 1B of this section, the similar restriction is applied on offenses related to court proceedings. If there is a court proceeding where such offenses happen, which is in the sections which I mentioned earlier, which has happened, then who should be complained? The person who is aggrieved. Who makes a complaint normally? The person who is aggrieved. Of course, somebody else who can observe and make a complaint in general is okay, but these are special cases. So if a public servant office is aggravated, they have to make a complaint. If a court has to make a complaint, and then only courts can take a cognizance of such complaint arising out of those court officers. And for example, if a witness comes in, a perjury during a trial. So if you go back, say for example, a matter is running in the chief family court, principal family court, and then there is some evidences which are filed by the one of the parties, which is completely fake, which is clearly visible and could be proved they are wrong. A claim is made for perjury by the other party during trial. The court will only take a cognizance of a formal complaint made by the judge. So that judge will then make a complaint to a JMFC that okay, there is a seems to be a perjury which has committed. Kindly make an inquiry into it, do a trial, and send back the judgment, or it whatever the court feels to be up to what level they want the other magistrate to go ahead and make an investigation. You cannot, as an individual, go to the magistrate and say there is a matter running in the court and there is a perjury which has happened. Please take cognizance of this and start a proceeding. It is not allowed. So there's some kind of control in those special cases. Now, what other thing it talks about? Section talks about withdrawal of complaints. Now, if there is a complaint which is originating, it gives a right to withdraw that complaint also. So public authorities who have filed a complaint may direct a withdrawal also of the complaint, and no further proceeding will take once it is withdrawn. But what is important is it cannot be withdrawn once the trial in the first instance has already concluded, ensuring that when proceedings have advanced significantly, they cannot be retracted lightly. Then it cannot be retracted lightly. If a public servant decides to withdraw a complaint regarding an alleged misconduct of another public servant, for example, hmm, after the trial has started, they would not be able to do so if the trial has reached its conclusion. So if a trial has been done and if the honorable court has all the beliefs by seeing all the facts and evidences, yes, this has happened, you just cannot come back and make it retract by sending an application saying, now I'm fine with it. So what is the other thing in the section is it defines the word court. It says in subsection 2, subsection 1B, offense related to court proceedings, then it defines what are the courts. The courts could be civil, revenue, criminal courts, etc. And also inclusive of the tribunals, which are constituted under Central State Act, which is everything. So every other court is identified and defined under this, which are named here. What is other thing? Subordination of the court, which is also part of this section, where this subsection provides a structure for identifying the subordinate status of the court, which is the last part. A court is deemed to be subordinate to the higher court to which appeals ordinarily lie from its decision. So the section also says that who is a subordinate court? The subordinate court is the court from which the appeals could be made in the higher court. So that court is a subordinate court of that court. And for civil court, they do not have appealable decrees. They are viewed as subordinate to the principal court having original civil jurisdiction in that area. But the provisions also say there are multiple appeal courts in case there are multiple appeal courts, or if appeals are available to multiple courts. The court with the lower appellate jurisdiction is considered the court to which the original court is subordinate. So, for example, an appeal has come from JMFC, it has gone to the session, then it has gone to the higher court, then it has gone to the Supreme Court. In all the cases, the appeals are in the multiple courts in this case. The court with the lower appellate jurisdiction is considered the court to which the original court is subordinate. In this case, the JMFC is subordinate to the session. Civil and revenue matter, when both the civil and revenue matters are possible, the court is classified as subordinate to either court based on the nature of the case related to that offense. So whatever is the nature of the offense, revenue or civil in nature, the whatever we discussed previously will be applicable. So if a civil court decision can be appealed to either a district court or a revenue court, either of it, it will be regarded as subordinate to whichever court takes the precedence. So wherever the appeal will move, that court become in that matter the subordinate to that particular court. So what is the practical implication? It gives a very clear judicial oversight on the procedure of protection of the public servant, but no misuse or confusion regarding, because it should come within that organization of public servant only. It also talks about the complaints arising out of the court proceedings, which is also something streamlined and scoped within the scope of the court officials. Then the courts are defined, and the withdrawal is also allowed only up to the extent when there is no conclusion made by the court. And it also streamlines the process of defining which are the appeal court for the other courts in case if the appeal is uh, directly to a hierarchy which is predefined, it is fine. But in cases when appeal can arise from one court to multiple different courts, for example, a civil court, depending upon what kind of matter it was, it can go to a district court, it could go to as an appeal to a revenue court also. In that case, the subordination is considered of the court depending upon which the higher court the appeal has made. So that confusion is also clarified in that particular section. So this is about section number 215. Now we talk about section 216. This is procedure for witness in case of threatening, etc. So witness or any other person may file a complaint in relation to an offense under section 232 of the Bharatiya Nyaya Sanhita 2023. Mosquito. A witness or any other person may file a complaint in relation to an offense under section 232 of the Bharatiya Nyaya Sanhita. So any witness or any person may file a complaint in relation to an offense under section 232 of Bharatiya Nyaya Sanhita, which is a procedure for witness in case of threatening, etc. So what is section 232? It talks about threatening any person to give false evidence. So if such a scenario comes, any person can make a complaint. So it says an authority to file a complaint for any witness or individual to file a complaint concerning offenses related to threats or intimidation, which is for a person who is a witness. And this provision emphasizes the importance of protecting the integrity of witness and other involved in legal proceedings. So this is something which is a matter where a direct complaint can happen. So it generally pertains to offense related to intimidating a individual, particularly aiming at a witness or a personal connect to ongoing legal proceeding, anybody. So such offense can severely undermine the judicial process by deterring the witness from providing truthful testimony. So as this is something which is aiding in the normal proceeding of the courts to deliver the justice properly, this section 216 gives a procedure for witness in case of threatening, etc. And then it allows that a witness or any person can come and file for any offense which is considered under section 232 of the BNS, which is threatening any witness. So implication of filing a complaint is protection of the witness, which is very, very important. A protection of witness is ensured by section 216 of BNSS. And again, it's a legal recourse that any intimidation or any threat which happens, which is obstructing the delivery of the justice, that has to be taken with iron hand. And that is why this is given under section 216. The practical consideration is basically it's a procedural guideline, but it's a role of law enforcement. It is helping to reinforce the law. Coming to section 217, prosecution for offenses against state and for criminal conspiracy to commit such offense. So no court shall take an cognizance of any offense punishable under Chapter 7 or under Section 196, Section 299 or subsection 1 of Section 353 of the BNS. So anything which is happening under Chapter 7 and which is of offense against the state. So any offense which is against the state, which is coming under Chapter 7, anything which is Section 196, which is promoting enmity between different groups of on grounds of religion, race, etc. That and anything related to Section 299 subsection 1 of Section 353. So 299 is nothing but deliberate and malicious acts intended to outrage religious feeling of any class. So it is also related to religious class and belief. And then finally to section 353, which is statements conducing to public mischief. So anything which is causing such kind of thing, which is religious in nature, which is disturbing the religious harmony or vary on various grounds, the division of the society, or anything which is against the state. So all of these, no court can take a cognizance of this. Or number B, a criminal conspiracy to commit such offense. Or number C, 1C, is any statement as is described in section 47 of Bharatiya Nyaya Sanghita. That also cannot be considered to be part of it, which is abatement in India or offenses outside India. So any such abatement also cannot be taken care except with the previous sanction of the central government, if the central government has or state government has some specific modifications. Second part of the section says, no court shall take cognizance of any offense punishable under section 197 of the Bharatiya Nyaya Sanghita, subsection 2, which is related to imputation, assertion, prejudicial to national integrity, any national integration related anything, or subsection 3 of section 353, which was part of the previous one also, which is related to statement conducing to public mischief. 2B says a criminal conspiracy to commit such offense except when there is a sanction by the central government, state government, or the district magistrate. Subsection 3 says no court shall take an cognizance of the offenses of the crime, criminal conspiracy punishable under subsection 2 of section 61 of the BNS 2023 other than the criminal conspiracy commit an offense punishable with death, imprisonment, or for life or rigorous imprisonment for a term of 2 years or upwards. So anything which is part of subsection 2 of subsection 61, which is criminal conspiracy, and then which is other than a criminal conspiracy to commit an offense punishable with death, imprisonment, or life. So the courts cannot take a cognizance. And then the last part of the section says the central government or the state government may before according sanction under subsection 1, 2, and the district magistrate may therefore according sanction under subsection 2, and the state government or the district magistrate may, before giving consent under subsection 3, order a preliminary investigation by a police officer not being below the rank of inspector, in which cases such police officer shall have the power to refer in subsection 3 of section 174. So what is the detailed explanation of this section is prohibition on taking cognizance. First of all, this is also one section like the previous one, which is talking about prohibition of taking cognizance. The previous one we're talking about in public servant related or public justice related or evidence document related. Now, the first section talks about prohibition on taking cognizance of what? The subsection 1 specifies that the courts are prohibited from taking cognizance of certain serious offences unless there is a prior government sanction. So the government, until has a sanction provided, they cannot take a cognizance. For example, offences punishable under specific provisions which are of related to integrity of the nation or any kind of religious upturn or churn. Any, which is number A. Number B, any criminal conspiracy to commit these offences also included in that, and abatement of such offences as described in 47, which is India or outside, until and unless the central or state government is having a previous sanction. So if the government has given a previous sanction in that regard, then courts can take an cognizance, otherwise not. What is the purpose of this? The purpose of these are very serious offenses against the state and the public security. And these have to be carefully reviewed before legal action can be initiated, preventing frivolous prosecutions. These are very serious matters. And any prosecution can happen in the name of a frivolous prosecution also. So to stop that frivolous prosecution, which will nothing but which will end of the day hamper the interest of the public, security of the nation, and the order in the state. To avoid all that thing, this particular section says you cannot take a cognizance by default until and unless this is something which is already being sanctioned by the government. Sanction means allowed by the government in certain GRs, and they have given that permissions, those permissions. Second part of the section talks about the further prohibition, subsection 2. So in addition to the earlier provisions, this subsection states that no cognizance can be taken of further prohibitions. Offences punishable under 197 or 353 without prior government sanction. And it emphasizes the need for higher oversight on offences that threaten state interest or are particularly severe in nature. So it is putting a lock and key mechanism. And for criminal conspiracy, part 3 says courts cannot take cognizance of criminal conspiracies punishable under section 61 other than those punishable by severe penalties of death or life imprisonment of etc., or rigorous imprisonment of 2 years or more, unless there has been prior consent from the state government of the district magistrate. So this goes to the state government of the district magistrate. So anything which is related to criminal conspiracy, this is only the subject of the state, that they can come back and either look into the sanction from the prior consent from the state government or sanction from the state government or permission from the district magistrate, which in turn reflects what the state thinks. So all district magistrate may only bring in such orders or such instructions in the or provide such consent which is in sync with the state government. So but there are exception also given in the criminal conspiracy part, which is if the conspiracy falls under the provision of section 215, which relates to public authority and justice, no prior consent is required. So if that is related to something which is related to section 215 of Bharatiya Nyaya Sanhita, in that case, there is no prior consent which is required, which is refusing to sign any statement, etc. So if the conspiracy falls under this provision under section 215 of CRPC, BNS, which states a public authority, just no prior consent is required. So if there is which is something, say for example, 215, if there is something which is having a sanction of the state, the sanction of the central government or a consent of a district magistrate, for that section 215 of BNS, which is falling purely under the authority of this court, the criminal court, then there is no prior consent is required. Then they can go ahead which is just a reverse statement of whatever we have just made. Because whatever we have statement made earlier for the section 215 of BNS, we talked about what in what situations they cannot. So if all those things are apart from that, there is no consent required to take a cognizance. And what is the implication of this? The section offers a layered approach to prevent unwarranted action. So there is a layered approach where certain places central and state government have to bring in sanctions. Certain places state government and the district magistrate has to bring in sanction or consent. So this helps a layered way of control. Now, part 4 of the section talks about the preliminary investigation. So before granting sanction or consent, as outlined in the previous subsection. So there was a mentions of sanction from the government or consent from the government collector, district magistrate. So the central government or state government, either of the cases, those people can mandate a preliminary investigation by a police officer, at least the rank of an inspector, to go and check. And the police officer will have specific investigation power as referred in section 174(3), ensure that a thorough examination of the allegation is done and he presents the report. And this helps mitigate any wrongful prosecution by ensuring that there is enough factual basis. So these are very serious allegations, and if the serious allegation has to be done, there has to be very strong lock and key mechanism available to stop any misuse of the same. What is the practical implications coming out of it? Judicial oversight, as always, protection to the individual. It is not that somebody, one politician who is unhappy with you or one officer which is unhappy with you can go ahead and file such a case of you planning conspiracy against the nation, etc., conspiring against the state, offenses against the state, etc., can be filed, which is very, very dangerous and very heavy allegations. So there is a protection given. In fact, the protection is called out first before the punishment. So the intention of the section 217 is to ensure that in the minds of the legislature, it was there while codifying this particular section that these are very serious allegations and there should be a layered approach to ensure to maximum extent nobody is unnecessarily put and blamed and convicted or at least alleged in such situations. And this helps in establishing a very strong process to not let that happen. So which is section 207, a very beautiful section which talks about how the people are protected from unnecessary allegations or prosecutions under the uh, offenses against the state or order of the state. Then we come to section 218. Section 218 is prosecution of judges and public servant. Now, this is also a very, very important thing because there is a mechanism and security required where in a very systematic way, prosecution of the judges and public servant has to be taken care. Otherwise, this will become a fear for them unnecessary, which will not let them work also fearlessly. So when any person who is or was, so is or was both a judge or magistrate or a public servant not removable from his office, save by or with the sanction of the government, is accused of an offense. So somebody who cannot be moved from their office until and unless with the sanction of the government, if they were acting earlier or they are retired right now from that position, is accused of any offense alleged to have committed by him while acting or purporting to act in the discharge of his official duty. So that person has done this particular alleged to have committed this offense uh, while acting in that role or purporting to act in the discharge or in course of that seemingly doing the role of that particular position. No court shall take cognizance of such offence except with the previous sanction, save as otherwise provided in the Lokpal and Lokayukt Act. So until and unless there is a previous sanction, as per the Lokpal and the Lokayukt Act, the courts cannot take a sanction. And in the case of a person who is employed, which is subpart A. So section 218(1) said that what I mentioned just now until Lokpal and Lokayukt Act. Now going ahead with subsection 1A. It says in the case of a person who is employed or as the case may be was at the time of commission of the alleged offense employed in connection with the affairs of the union or the central government. Or point B says, in the case of a person who is employed, or the case maybe was at the time of commission of the alleged offense, employed in connection with the affairs of the state government. So in all both the cases, state government, provided that where the alleged offense was committed by a person referred to in clause B during the period while a proclamation issued under clause 1 of article 356 of the constitution was in force in a state, clause B will apply as if for the expression state government occurring therein the expression central government was substituted. So when the provided the person has committed by the alleged offense was committed by the person referred to in clause B during the period when proclamation under 356 was done, and it was controlled by the governor and the central government has overseeing everything, then read that particular statement in the subsection B where the person who is an employee of state government read replaced by the expression central government. So it should be considered as a central government because that is in control that point of time. Provided further that the such government shall take a decision within a period of 120 days from the date of receipt of the request of sanction, and in case it fails to do so, the sanctions shall be deemed to have been accorded by such government, provided also that no sanction shall be required in case of a public servant accused of any offense alleged to have been committed under section 64, 65, 66, 68, 69, 70, 71, 74, 75 to 79, which is related to sexual offense, voyeurism, or such kind of stalking, such kind of offenses, or section 199 or 200 of the Bharatiya Nyaya Sanghita, which is also where it is not applicable and which is related to public servant disobeying direction under law and punishment for non-treatment of victim. Part 2 of the section says no court shall take cognizance of any offense alleged to have been committed by any member of the armed force of the Union while acting or purporting the act in the discharge of their official duty except with the previous sanction of the central government. And number 3 says the state government may by notification direct that the provision of subsection 2, which is about the armed forces of the Union, shall apply to such class of category of the members of the force charged with the maintenance of public order as may be specified therein whenever they may be serving, and thereupon the provision of that subsection will apply. And for the expression central government occurring therein the expression state government. So wherever they are under operations and controls of the central government, although they are part of the state government, and those situations where they are being controlled by the central government, the expression would be read and understood as the central government. Number 4, subsection part 4 says, notwithstanding anything contained in subsection 3, which is about the switching of the word state government to central government, the no court shall take cognizance of any offense alleged to have committed by member of the forces charged with the maintenance of public order in a state while acting, purporting the discharge of his official duty during the period while a proclamation issued under 356 is gone, where the central government is in charge. And section 2185 says the central government or the state government may determine the person by whom, the manner in which, and the offense or offenses for which the prosecution of such judge, magistrate, or public servant is to be conducted, and may specify the court before which the trial to be held. So detailed explanation, if we see, it's talk about the authority and the limitation on prosecution. So basically it says who is authorized for prosecution of the judges and the public servant, and what is the limitations and the manner in which it has to be done. So it establishes a strict limitation on the prosecution of the judges, magistrates, and public servant regarding offences committed while performing their official duties. This acknowledges the need for legal protection for these officers to provide while promoting accountability. So while accountability is promoted, but then there is a legal protection given. Now, what is the subsection word 1 talking about? It talks about the cognizance of the restriction of the cognizance. So judges and the public servant, a judge or magistrate or a public servant who cannot be removed from the office without the government sanction, they cannot be prosecuted for the offences committed during the discharge of their official responsibilities unless there is a government sanction already around that. Or for specific offences. For example, the provision include provision for employees acting in the connection with the affairs of the union, employees acting in the connection with the affairs of the state. So these provisions include provisions for these areas, and there are additional provisions which are mentioned in terms of cognizance restriction is when a public servant is accused during a time of presidential rule and the requirement for sanctions switches from the state government to the central government. They have to give a sanction. So same employee of the state government, when it was no proclamation under 356 happens in the state, the state government is supposed to give the sanction. If that is the period when the 356 presidential rule is there, in that case, the central government is applicable to provide sanction in that duration. So deemed sanction, if a decision regarding the sanction is not made, any decision which is regarding the sanction, it is not made within 120 days, the sanction is considered to have been granted by default. So if a decision is not made regarding the sanction within 120 days, so if the state government, central government is not giving any sanction in that regard, and it is not done within 120 days, it is considered to be granted by default. So they are given a sanction by default. So state government has come back and say no at within 120 days. Exemption clause is also given in subsection 1, which says no sanction is required for public servant accused of offences committed with sexual offences, etc. For these reasons, there is no sanction of state, central government during presidential rule, central government sanction, nothing is required. They could be completely prosecuted, and there is no sanction required. And under 143 and 199 and 200 also, this is the same case where 143 is nothing but the trafficking of the person. 199 is public servant disobeying direction under law, and 200 is punishment for non-treatment of any victim. So all these conditions, there is these offences are considered serious enough to warrant any self-initiation of legal action, irrespective of government's action. So government's action is not required. The person could be prosecuted in these cases. Subsection 2 talks about cognizance of the armed forces, which we have been seeing in multiple sections, where any court is not allowed, no court may take any cognizance of any offense committed by a member of the armed forces of the union, central government during the discharge of their official duties without first obtaining the previous sanction of the central government. So this emphasizes the principle that military personnel are the affected, are afforded certain protections due to the nature of their work and responsibilities. They're given some benefits of that. Again, subpart 4 talks about application to the force maintaining public order. So the force which is maintaining a public order, for them the state government has the authority to extend the provision of subsection 2 to specific classes or categories of forces responsible for maintaining public order. So they are also immune to that. So regardless of where they are serving or not. So this allows flexibility in applying legal standards to different branches of law enforcement or military personnel as deemed necessary. Subsection 5 talked about special consideration during the presidential rule. Now, if there are some special considerations of this prosecution during the presidential rule, which is in scenarios where a proclamation under 356 of the Constitution is in force, the additional protection is applied to member of the forces charged with maintaining public order. They have got additional cover of protection under subsection 5 of section 218. So this protection aimed to safeguard their roles during the times of government challenges requiring prior approval from the central government for any proceeding. So they are protected specially by the central government in those scenarios. And the last subsection 6, which talks about authority on prosecution. So the central government or the state government retains the authority, which is no doubt. And they have authority to determine the individuals responsible for conducting the prosecution, who will prosecute, the manner in which the prosecution will happen, the specific offense for which prosecution is initiated, and the designated court where the trial will occur. So all that is controlled by the state and the central government, as mentioned in this section, subsection 6. What are the implications? This oversight ensure that the prosecution is aligned with governmental policy and the appropriate resources are allocated to handle serious allegations against public officials adequately. So practical implication is protection is of public servant, judicial integrity they try to maintain with this, and they try to streamline the process and not carry a chaos and file if fear in the minds of the public servant and the judges. They can work fearlessly. Now, under chapter 4, we are reading 215 to 222. We've reached to 219 now. So 219 talks about prosecution for offenses against marriage. So what happens? We are talking about the exceptions. So one exception was the previous one about the public servant and the judges. Now, prosecution of offenses against marriage is the next exception topic. So no court shall take cognizance of an offense punishable under section 81 to 84, both inclusive of Bharatiya Nyaya Sanhita. What is 81 to 84? 81 to 84 is, which is something related to marriage, related to crime. For example, 81 is cohabitation caused by a man deceitfully, including belief of lawful marriage. 82 talks about marrying again during lifetime of husband or wife. 83 talks about marriage ceremony fraudulently done, gone through without lawful marriage. And 84 talks about enticing or taking away or detaining with criminal intent a married woman. So in either way, so the courts, no court shall take cognizance of an offense punishable under these sections, except upon a complaint made by some person aggrieved by offense. So no third person can make such complaints. No third person who is not party to such matters cannot come back, and who is not personally aggrieved with the offenses, they can not come and make a complaint. So in all such these four cases, their complainant should be somebody who is aggrieved with these offenses. And who are the people who could be considered aggrieved as described further? So number A, where such person is a child or is of unsound mind or is having intellectual disability requiring higher support needs, or is from a sickness which is not letting him allow to take a decision, or dividing of motory blessings, and then infirmity, unable to make a complaint, or is a woman who, according to the local custom and manners, ought not to be compelled to appear in public. So maybe somebody who is not allowed to come in the public, or some other person may, with the leave of the court, make a complaint on his or her behalf. So in all these cases, some other person may, with the leave of the court, they have to first take permission from the court, make a complaint on his or her behalf. So this is first situation. A. Number B, what we are talking about. So the complaint cannot be made, cognizance cannot be made by the court in such scenarios unless a complaint is made by somebody. First condition was a child or mentally infirm or a woman who cannot make an appearance in public. So a third party can help with the leave of the court and make a complaint. Number B, where such a person is a husband and he is serving in any of the armed forces. So when in such situation, in the sections 81 to 84 scenario, such person is a husband and the wife goes ahead and puts an allegation, or the lady goes in allegation, and he is serving in an armed force of the union under conditions which are certified by his commanding officer as precluding him from obtaining leave of absence to enable him to make a complaint in person. Some other person authorized by the husband is, in accordance with the provision of subsection 4, may make a complaint on his behalf. So number 4, we'll go ahead further once we read. So in this such a situation, when there is a party where the husband is in armed forces, that person who cannot actually go out on leave or of absence to enable him to make a complaint himself, that person can authorize somebody as per the provision of subsection 4, which we'll read in some time, and that person can make on his behalf. So first part was child and woman. Second is of a husband who is party to such an offense and is serving in armed forces and cannot take a leave. Number C, where the person aggravated by the offense punishable under 82 of the Bharatiya Nyaya Sanhita. Now we are talking purely about only about the number 82, which is marrying again during lifetime of husband or wife. In this case, where the person aggravated by an offense punishable under 82 of the BNS is the wife. Complaint may be made on her behalf by her father, mother, brother, sister, son, or daughter, or by her father's mother, brother, or sister, or with the leave of the court by any other person related to her by blood, marriage, or adoption. So these people are the people who are persons aggravated by the offense or connected to the person. Subpart 2 of the section says, for the purpose of subsection 1, where we talked about the parties who can make a complaint and how. No person other than the husband of the woman shall be deemed to be aggravated by an offense punishable under section 84 of the Bharatiya Nyaya Sanhita, which is enticing or taking away or detaining with criminal intent a married woman. If this happens, somebody entices and runs away, marries a married woman, takes her away, runs away with her. So this, in these cases, no other person other than the husband of the woman shall be deemed to be aggravated. So this is the only party is the husband. Subsection 3 says, when in case falling under clause A of proviso subsection 1, which is the child, woman, the mentally infirm person, the complaint is sought to be made on behalf of a child or a person of unsound mind by a person who has not been appointed or declared by a competent authority to be the guardian of the child or of the person of the unsound mind, and the court is satisfied that there is a guardian so appointed or declared, the court shall, before granting the application for leave, cause notice to be given to such guardian and give him reasonable opportunity for being heard. So this is a special case in case of child and person of unsound mind. Subclause 4, which we discussed in subpart subsection 1, and we talked about how the husband, in this case, in subsection B, will be able to file a complaint. So the authorization referred in clause B of the proviso of subsection 1 shall be in writing, shall be signed or otherwise attested by the husband, shall contain a statement to the effect that he has been informed of the allegation upon which the complainant is to be founded, shall be countersigned by the commanding officer, and shall be accompanied by the certificate signed by that officer to the effect that leave of absence of the purpose of making a complaint cannot be allotted or given for the time the being granted to the husband. So the process is this. And subsection 5 says, any document purporting to be such an authorization and complying with the provisions of section 4, any document purporting to be a certificate required by that subsection shall, unless that contrary is proved, be presumed to be genuine and shall be received in evidence. So it will be considered genuine. While subsection 6 says, no court shall take cognizance of the offences under section 64 of the Bharatiya Nyaya Sanhita, where such offence consists of sexual intercourses by a man with his own wife, the wife being under 18 years of age, if more than 1 year has elapsed from the date of the commission of the offence. So the court shall not take an cognizance of an offence under 64 for the under Bharatiya Nyaya Sanhita, where such offence consists of sexual intercourse by a man with his own wife, and the wife being under 18 years old. So they cannot be cognizant by the court. A rape cannot be called out. And subsection 7 says, the provisions of this section apply to the abetment or attempt to commit or an offence as they apply to the offences. So all these offences are allowed. So what do we understand from the section? This section in turns 219 talks about authority and limitation of prosecution. What is the authority and limitation of the prosecution and how to apply? So it stipulates that the no court can take cognizance of specific offences related to marriage, 81 to 84 BNS, unless a complaint is formally made by an aggrieved party. The aggrieved parties are defined, and this addresses the offences including but not limited to adultery, bigamy, etc., etc. Subsection 1 of the section says the aggrieved parties are only individual directly affected by the alleged offences. They can file complaint and they foster a legal responsibility, which is regarding to marriage-related offences while preventing frivolous lawsuit. To avoid a frivolous lawsuit, they are allowed. The public interest in this case is the provisions which seek to ensure that the offences against the marriages are brought to the attention of the court by those whose personal rights have been directly impacted or violated. So only those aggravated parties can done. But there are some special considerations given. What are the special considerations given? Apart from the aggravated party who can file, if the person aggravated is a child or unsound mind, or due to infirmity, they cannot do, or another individual then can come and file on their behalf, in spite of they being the aggrieved party, which is subject to a court's permission. So this ensure that the vulnerable individuals still have a mechanism for legal right. If they cannot stand for themselves, somebody can do, but with the leave of the court. The second consideration which was given was the in aggrieved party is the husband who is in armed forces, who cannot be allowed by his commandant or commanding officer uh, leave for of absence, and he obtains a certificate in that perspective. So that is again a special consideration somebody else can do on his behalf. And number C, if the wife is the aggrieved party under section 82 and complaints can be made on her behalf by close relatives such as her parents, etc., etc., which is nothing but related to bigamy, and but it has to be done with the leave of the court. The court has to provide a permission to allow that person apart from the aggrieved party in such situation. Aggravate parties has been defined in the subsection 2, which are regarded to punishable under section 84, that it could only be husband. If somebody's wife has been taken away and somebody else's wife is taken away and got married with somebody else, there can be only one aggravated party, which is the husband. Now, subsection 4 is about the guardian notification, which was in case of uh, subsection 3. Subsection 3 talks about the guardian notification, sorry, not 4. So in this case, where a complaint is filed on behalf of the child, which is mentally unsound person by someone not appointed as their guardian, the court may notify the appointed guardian before getting permission to the proceed. This will ensure that the right of those the incapable of making decision for themselves are respected. They're getting that right, respected. Subsection 4 talks only about the authorization requirement, which is for complaints made on behalf of a husband, which is serving in armed forces, and how that could be made. It has to be bring in a detailed format about the husband, aware of the allegation, what are made, and the countersigned by the commanding officer, giving a certificate confirming he cannot go on leave. Subsection 5 talked about presumption of validity. So documents which are following the specification outlined in subsection 4, if they are in order as per the guideline, they are considered genuine until unless proved. So by default, there is a presumption of they being genuine. There is no validation further required to validate, get an affidavit done, etc., etc. They are presumed to be authentic, genuine by hands, by seal and signature of the in hands of the commanding officer. The subsection 6 talked about the time limit for such cognizance. So the subsection says that uh, the court cannot take cognizance of offences under section 64, which may involve sexual intercourse by a man with his own wife when she is under 18 years of age, if more than 1 year has elapsed since the commission of the offence. So after 1 year, if somebody goes report, there is no cognizance in the court. This provision helps to set a time limitation for initiating a legal action, ensuring that such cases are addressed in a timely manner. So it promotes you do it within a year of time. And applications of offences of abetment is mentioned in subsection 7, which talks about the provisions of this section apply to attempts or abatement of the specific offences and they ensure that the indirect involvement in commenting committing offences are again marriage is treated with the same seriousness as direct actions. So this is a large section again which talks about safeguarding vulnerable individuals or people who are vulnerable because of the seasonal difficulties like an army person, protecting against the arbitrary prosecution of the people because then there is a check and balance control and promoting a due process of law. Coming to section 220 under chapter 3, chapter 3, yes. This is the exception to the general principle of moving criminal code. It says prosecution of offences under section 85 of the Bharatiya Nyaya Sanhita. What is 85 number section of Bharatiya Nyaya Sanhita? It is a husband or relative of husband of a woman subjecting her to cruelty. That is section 85. So in this section 220, it says prosecution of offences under this section of the BNSS is discussed in section 220. So this is what is the exception in this general principle for this is no court shall take cognizance of an offence punishable under section 85 of the Bharatiya Nyaya Sanhita except upon a police report of fact which constitutes such offence or upon a complaint made by the person aggrieved by the offence or by her father, mother, brother, sister or by your father's or mother's brother or sister or with the leave of the court by any other person related to her by blood, marriage or adoption. Very straightforward section which talks about the the violence which is committed against a married woman by her husband and by her in-laws, and it talks about the authority and limitation on prosecution. So it says that specific requirements for prosecuting offences defined under section 85, a husband relative of husband of a woman subjecting her to cruelty, the section emphasizes the necessity of formal process to ensure that cognizance is only taken when appropriate complaints or reports have been filed. Only then a cognizance can be taken up. So what are the conditions for the cognizance? The conditions for the cognizance are first of all the police report. So if there is an official police report detailing the false facts constituting to the offence, yes, it can be cognizance can be taken, or a formal complaint if it is done by the aggrieved party, her father, mother, brother, sister, or maternal, paternal, aunt or uncles. So who can come and sign this, make this complaint under her behalf. And the leave of the court, anybody else on the earth can do this if the court is satisfied that person is a suitable person to do and the only person to do. What is the importance of the provision? It protects the victim, especially the woman, and it supports for the vulnerable individual. Such a provision is a deterrent to the people as these parties can make a complaint in such scenarios. Section 221, which is the second last in chapter 3, is cognizance of offense. So no court shall take cognizance of an offense punishable under section 67 of the Bharatiya Nyaya Sanhita, where the persons are in a marital relationship except upon prima facie satisfaction of the fact which constitute the offense upon a complaint having been filed or made by the wife against the or the fact which constitute that the offense upon a complaint having been filed or made by the wife against the husband. So nobody else can make such complaint, which is sexual intercourse by husband upon his wife during separation. So if this is happening, who is the person who can report is only and only the wife. So what is the detailed explanation? It talks about the context of the cognizance. It says The specific circumstances under which the court may take a cognizance of offense under 67, that is a sexual intercourse by husband upon his wife during separation. This section is particularly relevant in the context of offense occurring within the marital relationship, reflecting sensitivity to familial dynamics and the nature of such offenses. So it is something which is happening, but the judiciary and the legislature probably have also thought in that direction is they wanted to give a sensitive hand to this because this is end of the day still a marital matter. So conditions for taking a cognizance is a marital relationship should have existed. So this, for this section to be executed, a pre-marital relationship should be there. The condition acknowledges that a complexities and nuisance of legal action are within the marriage. So this is something within the marriage. Then prima facie satisfaction. The court must establish a prima facie case, meaning there must be sufficient initial evidence to suggest that an offense was occurred before proceeding. And number C is complaint required. So cognizance can only be taken upon a formal complaint filed by the wife against the husband. So this stipulation places that the responsibility of the initial legal action firmly on the shoulder of the wife within the four corners of the marriage, and she can only be the aggrieved party. Number three, the what is discussed in the section is 221 is importance of this provision is the protection of the marital integrity, and the wife can establish a prima facie case, but the section aims to prevent a frivolous and retaliatory claim also. It ensures the accountability from both the parties and empowerment for women as well. Fourth part of the section says practical implications, which is judicial efficiency and promoting fairness. So, which is very, very important. Last section of the chapter is section 222, which is prosecution for defamation, which is a special case. So, no court shall take a cognizance of an offense punishable under section 356 of the BNS, which is defamation, except upon a complaint made by some person aggravated by the offense. So, if your defamation has happened, only you can come back and make a complaint, provided that where such person is a child or is of unsound mind or having intellectual disability or is from sickness, cannot help himself or herself, or infirmity, unable to make a complaint, or is a woman who according to the local custom manner cannot be compelled to appear in public. In all such scenarios, some other person may, with the leave of the court, then make a complaint on his or her belief. Part 2 of the section says, notwithstanding anything contained in this Sanghita, when an offense falling under section 356 of Bharatiya Nyaya Sanghita is alleged to have been committed against a person who at the time of such commission is the President of India, the Vice President of India, the Governor of a state, the Administrator of a Union territory, or a Minister of the Union, or a state or of a Union territory, or any other public servant employed in connection with the affairs of the Union or of a state in respect of this conduct in the discharge of the public function, a court of session may take cognizance of such offense without the case being committed to it upon the complaint in writing made by the public prosecutor. So in such scenarios, the court of session will take a cognizance of such offense without the case being committed to it. It can directly take only upon a complaint in writing made by the PP, which is a public prosecutor. And this is for defamation of such people. Subsection 3 says every complaint referred to in subsection 2 shall set forth the fact which constituted the offences alleged, the nature of such offence, and such other particulars are reasonably sufficient to give notice to the accused of the offence alleged to have been committed by him. While subsection 4 says no complaint under subsection 2 shall be made by the public prosecutor except with the previous sanction. Now, we mentioned for so and so people, the public prosecutor will make an application, a written complaint, and then the court of session can take a cognizance of it, but then they cannot also do except with the previous sanction of the state government. So, in case of a person who is or has been the governor of the state or a minister of that government, in the case of any other public servant employed in connection with the affairs of the state, on the government in any other cases, no court of session shall take cognizance of an offence under subsection 2 unless the complaint is made within 6 months from the date on which the offence is alleged to have been committed. So there is a time limitation also of 6 months, and nothing in the section shall affect the rights of the person against whom the offence is alleged to have been committed to make a complaint in respect of that offence before a magistrate having jurisdiction or power of such magistrate to take cognizance of the offence upon such complaints. So what does it talk about? Section 221, the 222, the last section in the exceptions to the general principle of moving criminal courts is authority and limitation on prosecution. So it provides a detailed guideline for the prosecution of defamation offences obtained under section 356 of Bharatiya Nyaya Sanhita (BNS), emphasizing that the process involved in filing complaints and the necessary approvals needed before a court can take cognizance. Then subsection 1 talks about complaints by aggrieved person can only happen. The person who is aggravated who can only make a complaint. Special consideration is the aggrieved person is a child, etc. Then a third person who can stand on their behalf, for example, a minor. Then subsection 2 talks about a high profile case. It says that if these offenses has to occurred against the high ranking officials like president, vice president, governor, ministers, public servants, during the discharge of official duty, a court of session may take cognizance without being committed, and the complaints in this case must be come from a public prosecutor, reinforcing the serious nature of accusation. For example, if a minister is defamed, a defamation happens to a minister, a union minister, a state minister, the public prosecutor can file a complaint directly in the court of session against that person defaming the such minister. The subsection 3 talks about every complaint filed under the section must detail the facts constituting the offense. So if the complaint is being made, there should be a detail on the facts constituting the offense, and it should specify the nature of the offense that and include sufficient particulars to adequately inform the accused of the charge they face. The requirement promotes the transparency and fairness in the legal process. Implication is by clearly defining what must be individual included in the complaint. The count ensures that the accused is given proper notice. The part 4 is the government sanction, which is a complaint filed by the public prosecutor in case involving high profile individuals or public servant must be accompanied by prior sanction from either the relevant state government or the central government, which is appearing on the individual involved. Now, for the complaints against the governor or minister of state, the sanction should come from the state government. And for any public servant to which the matter involves the central government, the sanction must be obtained from the central government. So the purpose is to require this. The requirements ensures that basically the prosecution is governed by oversight, reflecting the seriousness of the allegations against public figure and maintaining administrative controls over legal proceedings. Then it talks about a time frame limitation also. This subsection establishes a 6-month limitation period until which it has to be done. And the right of aggrieved person is given in section number 6, where the provision in this section basically is emphasizing that the person aggravated defamation has the right to file a complaint before a magistrate with jurisdictional authority. So this is about section 222. So we could only complete today until chapter 3. So chapter 4 and 5 remains. We'll continue from tomorrow on that. Let me stop the recording.